When two companies go to war over a contract, the default move is to file a lawsuit. But the courtroom is a centuries-old machine built for rigorous, formal procedures. When a supply chain is actively collapsing, that machine grinds to a halt. The reality is that commercial conflicts take highly specific forms. A disagreement over the physical rot of a grain shipment requires a completely different approach than a spreadsheet deadlock over a contractor's final payout. This diagram categorizes these conflicts into two distinct pillars. On the left, we have sensory or quality disputes, issues of physical condition. On the right, mathematical or quantum disputes, where liability is known but the exact dollar amount is contested. Forcing every one of these highly specialized problems through the exact same legal bottleneck destroys capital. To resolve disputes efficiently, the adjudicative process has to be engineered to match the specific nature of the conflict. In the global commodities trade, millions of dollars change hands every single day based on the exact condition of a harvest. If a buyer rejects a cargo of rubber or grain, claiming it arrived spoiled, the disagreement is entirely about physical reality, not legal interpretation. Bringing in lawyers to cross-examine witnesses about the physical state of a cargo hold wastes time while the product degrades. Instead, the industry relies on a mechanism known as Look-Sniff arbitration. It removes formal hearings and written submissions entirely. The parties appoint an industry expert to act as the sole tribunal. That expert travels to the site, inspects the goods, and issues a final, binding award based strictly on their own direct assessment of the product. No legal briefs, no court dates, just smelling the grain. There are strict boundaries here. If one party alleges fraud, or if there is a break in the chain of custody, the Look-Sniff mechanism instantly fails. It is blind to complex legal questions, but when the core question is empirical, is this crop up to grade or not? Stripping away the legal posturing and deferring to raw sensory expertise delivers an immediate commercial resolution. Let's look at the other side of the spectrum. Imagine a massive construction site where a contractor has clearly made a mistake. The liability is accepted. The only disagreement left is the exact dollar amount required to fix it, a situation known as a quantum-only dispute. In standard arbitration, a predictable psychological trap emerges. The claimant demands an absurdly high payout, and the respondent counters with an insultingly low offer. Both sides assume the arbitrator will simply split the difference and award a middle ground. Flip-flop arbitration solves this. The arbitrator is legally forbidden from compromising. They must choose one party's submitted figure exactly. This weaponizes the fear of losing. If you submit an inflated claim, you guarantee the arbitrator selects your opponent's number. The sheer risk of complete financial defeat forces both sides to abandon bad faith negotiating tactics. They have to submit the most realistic, defensible number possible before the hearing even starts. Flip-flop arbitration does not resolve deadlocks by calculating math. It resolves them by engineering a system where honest, realistic behavior is the only profitable strategy. You cannot execute these precision methods in a vacuum. Deploying them requires a sophisticated institutional framework and clear procedural rules agreed upon well in advance, often administered by a specialized center. This decision tree maps the deployment logic. Look-Sniff handles physical conditions, Flip-flop handles quantum deadlocks, and traditional arbitration takes complex law. Applying the wrong tool breaks the process. Forcing complex legal arguments into flip-flop traps the arbitrator into picking an extreme, breaking commercial justice. This is why the midnight clause is so dangerous. When parties treat their dispute resolution agreement as an afterthought, tacking it onto a contract at the very end of negotiations, they fail to define which specific rules will govern a crisis. By the time a massive supply chain disruption or a construction failure hits, the framework is already locked. The ultimate outcome of an arbitration is decided entirely by having the foresight to match the adjudicative tool to the problem long before the first claim is ever filed.